Question 1. A notary public sequential journal must be kept. A. In a public records office for safekeeping. B. In a locked and secured area under the direct and exclusive control of the notary. C. With the notary's employer, if the employer paid for the commission. D. At the county clerk's office where the notary's oath is on file. Answer: B. In a locked and secured area under the direct and exclusive control of the notary. The correct location is a locked and secured area under the notary's exclusive control, ensuring the confidentiality and integrity of the journal's contents. The journal contains private information about signers, and protecting it from unauthorized access is a primary duty of the notary public. For example, this could be a locked desk drawer or a safe to which only the notary has the key or combination. Always remember that while the journal is a public record, you are personally responsible for its security at all times. Question 2. If a notary's official seal is lost, stolen, misplaced, or rendered unusable, the notary must: A. Order a new seal immediately and continue notarizing with the old one if it is found. B. Immediately notify the Secretary of State by certified or registered mail. C. Wait until the commission expires to report the loss. D. File a report with the local police department only. Answer: B. Immediately notify the Secretary of State by certified or registered mail. A notary must immediately notify the Secretary of State in writing if their seal is lost or stolen to prevent fraudulent use. This notification is a critical step in protecting the public from potential forgeries or misuse of the notary's official identity. The law specifies that this notice must be sent via certified or registered mail, which provides proof of delivery. A good tip is to think of your seal as your official signature of office. If it's compromised, you must report it to your commissioning authority right away. Question 3. What is the main purpose of an acknowledgement? A. For the signer to swear that the contents of the document are true. B. To certify that a document is a true copy of an original. C. For the notary to verify the signer's identity and that the signature was willingly made. D. To have the signer sign the document in the notary's presence. Answer: C. For the notary to verify the signer's identity and that the signature was willingly made. The core purpose of an acknowledgement is for the signer to declare to a notary that they voluntarily signed the document for the purposes stated within it. The notary's role is to positively identify the signer and certify this declaration, but not to attest to the truthfulness of the document's content, which is the function of a jurat. For an acknowledgement, the key is that the signer confirms they signed the document. They do not have to sign it in the notary's presence. Remember it this way: the signer is acknowledging their own signature. Question 4. When a member of the public submits a written request for a photostatic copy of a journal line item, the notary must respond within A. 15 business days. B. 30 calendar days. C. 10 calendar days. D. 5 business days. Answer: A. 15 business days. A notary must respond to a written request for a copy of a journal entry within 15 business days. This timeframe is set by law to ensure timely public access to these records while giving the notary a reasonable period to comply. Upon receiving the request, the notary must provide a copy of the specific line item, charging no more than 30 cents per page. A helpful way to remember this is to associate the 15 days with the standard $15 fee for most notarial acts, linking two key numbers in California notary law. Question 5. A notary public who is not a licensed attorney is advertising their services in Spanish. What specific disclosure must be included in the advertisement? A. I am not a lawyer and cannot give legal advice. B. My notary services are not a substitute for legal counsel. C. I am not an attorney and, therefore, cannot give advice about immigration or any other legal matter. D. All fees are set by the state of California. Answer: C. I am not an attorney and, therefore, cannot give advice about immigration or any other legal matter. California law requires this exact phrase, along with a fee disclosure, in any non-attorney notary's advertisement in a foreign language to prevent the unauthorized practice of law. This rule is particularly aimed at preventing notaries from being mistaken for a notario publico, which in many Latin American countries is a high-level legal professional. The specific wording is mandatory to clearly inform the public about the limits of the notary's authority. Always use the exact statutory language to avoid severe penalties. Question 6. A California Notary Public's jurisdiction is A. Limited to the county where their oath and bond are on file. B. Statewide. C. Limited to their principal place of business. D. Nationwide. Answer: B. Statewide. A notary public commissioned in California has jurisdiction to perform notarial acts anywhere within the state's borders. While a notary files their oath and bond in their principal county of business, their authority is not confined to that county. For example, a notary from Los Angeles County can legally notarize a document for a client in San Francisco County while visiting there. A good way to remember this is that your commission is from the state of California, not from a specific county, so your authority extends throughout the entire state. Question 7. A Signer's driver's license expired 3 months ago, but all information on it is current. Is this an acceptable form of identification? A. Yes, because the information is still accurate. B. No, identification documents on the statutory list must be current or issued within the past 5 years. C. Yes, if the notary personally knows the signer. D. No, because driver's licenses are never acceptable once expired. Answer: B. No, identification documents on the statutory list must be current or issued within the past 5 years. The correct answer is no, because California law requires that an ID from the approved list must be current or, if expired, have been issued within the last 5 years. The key concept here is satisfactory evidence, which has strict legal requirements for validity and issuance date to ensure the ID is reliable. Since the license expired only 3 months ago, it was likely issued more than 5 years ago, making it unacceptable. Always check both the expiration date and the issue date when an ID is expired. Question 8. A notary is asked to notarize her brother's signature on a document transferring ownership of a car to their mother. The notary receives no financial benefit. This notarization is A. Permitted, because there is no direct financial benefit to the notary. B. Prohibited, because a notary cannot notarize for immediate family members like a sibling. C. Prohibited, because the notary has a direct financial or beneficial interest in the transaction. D. Permitted, but only if another non-related person is also signing. Answer: C. Prohibited, because the notary has a direct financial or beneficial interest in the transaction. This act is prohibited because the notary has a beneficial interest, even if not a direct financial one, as the transaction involves immediate family members. California law states a notary has a disqualifying interest if they are a party to or have a direct financial or beneficial interest in the transaction. A transaction involving a spouse, parent, or child is presumed to be a beneficial interest for the notary. To avoid conflicts of interest, a notary should always refuse to notarize for immediate family members, even when a direct payment isn't involved. Question 9. For which of the following documents may a right thumbprint be required in a notary's journal? A. A deed of trust affecting real property. B. A vehicle title transfer. C. A prenuptial agreement. D. A business contract. Answer: A. A deed of trust affecting real property. A right thumbprint is mandatory in the journal entry for any document affecting real property, such as a deed of trust, quitclaim deed, or grant deed. This requirement was implemented to combat real estate fraud by creating a biometric link between the signer and the journal entry. If the signer is physically unable to provide a right thumbprint, the notary should use the left thumbprint or any available finger and note this in the journal. Remember, if the document involves real property, a thumbprint is almost always required. Question 10. A subscribing witness is used when a principal signer A. Cannot appear before the notary. B. Refuses to sign the notary journal. C. Does not have acceptable identification. D. Is deceased. Answer: A. Cannot appear before the notary. The subscribing witness procedure is used to prove the execution of a document when the principal signer cannot personally appear before the notary. The subscribing witness appears before the notary, takes an oath, and states that they either saw the principal sign the document or heard the principal acknowledge their signature. This witness effectively stands in for the principal for the purpose of proving the signature. This is a rare but important procedure to know for situations where a signer is physically unable to travel. Question 11. When a person who cannot write signs a document using a mark, how many witnesses are required by the notary? A. One witness, who must sign the person's name next to the mark. B. Two witnesses, one to write the person's name and one to act as a general witness. C. Two witnesses, who must both watch the person make their mark. D. No witnesses are required if the person can be identified with a valid ID. Answer: C. Two witnesses, who must both watch the person make their mark. For a valid signature by mark, two witnesses are required to observe the signing and must sign their own names on the document as witnesses. One of these witnesses must also write the signer's name next to their mark, and the notary should record the witness's information in the journal. This two-witness rule provides an extra layer of verification to ensure the mark was genuinely made by the person who could not write their name. Think of it as a two-person confirmation for the signature by mark. Question 12. A notary who changes their business or residence address must notify the Secretary of State. A. Within 30 days of the move. B. Within 10 days of the move. C. Immediately upon moving. D. When they renew their commission. Answer: A. Within 30 days of the move. A notary must provide written notice of an address change to the Secretary of State within 30 days of the change. This requirement ensures that the state has current contact information for the notary, which is essential for official communications and public records. Failing to report the change in a timely manner can result in fines. A simple tip is to remember the number 30 for this deadline, just as you remember 15 for journal requests and fees. Question 13. A jurat certificate requires that the signer A. Present two forms of valid identification. B. Acknowledge that they understand the document. C. Sign the document in the presence of the notary. D. Provide a thumbprint for the journal regardless of document type. Answer: C. Sign the document in the presence of the notary. A key requirement of a jurat is that the document must be signed in the notary's presence, as the notary is certifying that they witnessed the signature being made. This is different from an acknowledgement, where the signer can have signed the document previously. For a jurat, the notary first administers an oath or affirmation, and then the person signs, solidifying their sworn statement. Just remember, for a jurat, you must see the signature happen. Question 14. What is the maximum fee a California notary may charge for administering an oath for a deposition? A. $15 for the oath, plus $7 for the certificate. B. $30. C. $15. D. $7. Answer: A. $15 for the oath, plus $7 for the certificate. The fee structure for a deposition is unique. A notary can charge a total of $22 for this service. This fee is broken down into $15 for administering the oath to the deponent and an additional $7 for the certificate of the deposition. It's one of the few instances where multiple statutory fees are combined for a single, specific notarial duty. Always make sure to itemize these fees correctly in your journal to reflect the two separate actions performed. Question 15. A notary is asked to notarize a document written entirely in a foreign language that the notary does not understand. The notarial certificate itself is in English. The notary may a. Notarize the document after scanning it with a translation app. b. Proceed with the notarization if the signer can communicate with the notary directly. c. Refuse, as a notary cannot notarize a document they cannot read. d. Proceed only if a certified translator is present. Answer: b. Proceed with the notarization if the signer can communicate with the notary directly. A notary is permitted to notarize a signature on a document written in a foreign language, provided the notarial certificate is in English. The notary's duty is to notarize the signature, not to certify the contents of the document itself. As long as the notary can communicate with the signer to properly identify them and complete all journal requirements, the language of the document's body is not a barrier. The key is that all communication between the notary and signer must be direct, without a translator. Question 16. The term of a California Notary Public Commission is a. 2 years. b. 4 years. c. 5 years. d. 6 years. Answer: b. 4 years. A California Notary Public Commission is valid for a term of 4 years, beginning on the date specified in the commission. This 4-year term is a foundational piece of knowledge for any notary candidate. At the end of this period, the notary must complete the reapplication process, including passing the exam and filing a new oath and bond, to continue serving. A helpful tip is to mark your calendar a full 6 months before your commission expires to begin the renewal process. Question 17. If a principal signer is identified through one credible witness, the credible witness must a. Present a valid, unexpired ID to the notary. b. Be personally known to both the notary and the principal signer. c. Sign the principal's name in the notary's journal. d. Be personally known to the notary. Answer: d. Be personally known to the notary. When using a single credible witness for identification, that witness must be personally known by the notary. The witness must then swear or affirm, under oath, to the identity of the principal signer. The notary's personal knowledge of the witness provides the foundation of trust for identifying the principal. If the notary doesn't personally know any single individual who also knows the signer, then 2 credible witnesses, who don't need to be known by the notary, would be required instead. Question 18. A notary's official seal must contain all of the following except a. The notary's commission expiration date. b. The name of the county where the notary's bond is filed. c. The notary's sequential commission number. d. The notary's business address. Answer: d. The notary's business address. A notary's business address is not a required element on the official seal. The seal must legally contain 4 specific items: the words, Notary Public, the notary's name as it appears on the commission, the state seal, and the commission expiration date. Some manufacturers also include the commission number and the county where the oath is filed, which is also required. Your address can change, but your name, commission number, and expiration date are fixed for the term. Question 19. A notary who willfully fails or refuses to deliver their journal to a peace officer with proper authority when requested is guilty of a. Misdemeanor. b. Infraction. c. Felony. d. Civil offense only. Answer: a. Misdemeanor. Willfully refusing to surrender the journal to a peace officer upon request is a serious offense classified as a misdemeanor. This act carries potential penalties including fines and jail time, and it is grounds for commission revocation. The journal is a public record, and law enforcement may need to access it for investigations, so compliance is mandatory. This rule underscores the notary's responsibility to cooperate with legal authorities and the public trust placed in the position. Question 20. A notary may certify a copy of which of the following documents? a. A birth certificate. b. A passport. c. A power of attorney. D. A marriage certificate. Answer: C. A power of attorney. California notaries are authorized to certify copies of a power of attorney and, upon written request, entries in their own official journal. They are prohibited from certifying copies of vital records like birth or marriage certificates or publicly recordable documents like passports. For those documents, the signer must request a certified copy from the official agency that issued it, such as the county recorder or Department of State. Always remember the rule: you can only certify copies of a power of attorney or your journal entries. Question 21. A client presents a document for notarization that has already been signed. What notarial act can the notary perform? A. A jurat. B. A proof of execution by a subscribing witness. C. An acknowledgement. D. A protest. Answer: C. An acknowledgement. An acknowledgement is the appropriate act when a document has been signed before the signer appears before the notary. For an acknowledgement, the signer must appear and simply declare, acknowledge, to the notary that the signature on the document is their own and was made willingly. Unlike a jurat, the signature does not need to be made in the notary's presence. Just remember, acknowledgement means the signer is confirming a past action. Question 22. When a notary public resigns their commission, they must deliver their public journals to A. The Secretary of State's office in Sacramento. B. The county clerk of the county where their current oath of office is on file. C. Any notary public willing to accept them. D. Their former employer who paid for the commission. Answer: B. The county clerk of the county where their current oath of office is on file. Upon resignation, a notary has a duty to ensure their notarial records are properly preserved for the public. The law requires that all journals be delivered to the county clerk's office in the county where the notary's most recent oath and bond were filed. This ensures that the public can continue to access these records even after the notary is no longer active. Forgetting this step can lead to legal penalties, so make it a priority if you ever resign your commission. Question 23. A notary is asked to complete a jurat on a document, but the signer refuses to take an oath or affirmation concerning the truthfulness of the document's contents. The notary should A. Refuse to perform the notarization. B. Proceed with the notarization but note the refusal in the journal. C. Suggest the signer get an acknowledgement instead. D. Administer the oath to a witness instead of the signer. Answer: A. Refuse to perform the notarization. The notary must refuse to proceed because administering an oath or affirmation is a mandatory and defining element of a jurat. A jurat's purpose is to certify that the signer attested to the truth of the document's contents under penalty of perjury. If the signer is unwilling to take this step, the notarial act cannot be completed as requested. A notary can never skip a required element of a notarization. Question 24. The purpose of the $15,000 surety bond required of California notaries is to A. Pay the notary's salary for their term of office. B. Protect the public from financial harm caused by the notary's misconduct. C. Serve as an insurance policy to protect the notary from lawsuits. D. Pay for the notary's commissioning fees and supplies. Answer: B. Protect the public from financial harm caused by the notary's misconduct. The $15,000 surety bond is a financial guarantee that protects the public, not the notary. If a notary's negligence or willful misconduct causes a member of the public to suffer financial loss, the injured party can make a claim against the bond to recover their damages. It is important to remember that this is not an insurance policy for the notary. If the bonding company pays a claim, it will legally pursue the notary for reimbursement. Think of the bond as a protection fund for your clients. Question 25. A signer asks the notary, which notarial certificate should I use on this document, an acknowledgement or a jurat? How should the notary respond? A. Advise them that a jurat offers more legal protection. B. State that the notary cannot choose the type of notarial act for the signer. C. Choose the acknowledgement because it is more common. D. Attach both certificates and let the receiving agency decide. Answer: B. State that the notary cannot choose the type of notarial act for the signer. The notary must state that they cannot choose the type of notarial act, as doing so would constitute the unauthorized practice of law. The signer, or the party who drafted or is receiving the document, is responsible for determining which notarial certificate is required. A notary's role is to properly execute the requested certificate, not to provide legal advice on which one is appropriate for the transaction. A safe and correct response is to explain the difference between the acts and state that the signer must make the choice.